Welcome to the EDRM Global Webinar Channel. My name's Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery. Today's Doug Austin, and it is called Important eDiscovery Case Law Decisions for June of 2023 with our faculty experts, Doug Austin, the illustrious Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in our engagement council, and questions will be answered both during and at the end of the webinar, and this webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars. Now, this is a new platform. We want to give you a short introduction. You can actually engage on this. It's not just listen. We would love to hear your thoughts. So first of all, there's the media player, and that's where obviously my voice and slides will come through. The question mark is for your questions, and we can actually answer them one-on-one in writing at this point now, which is lovely. There's slides, and Doug will send you a link after the webinar to the slides. And then there's a paperclip for related content with speaker bios underneath. You can click those. You can get latest news. There's a question mark for help. And just like Zoom, we've got some smiley face emojis and other emojis for reactions. We highly encourage you to engage with them. There's some links to follow on social, to book a meeting, and to contact EDRM via email. And after the webinar at the ribbon, you can download a certificate of attendance from the engagement council after the webinar. And Kaylee Wallstead is EDRM's Chief Strategy Officer. She's here today too. Kaylee, tell us what resources we've got available.
Thanks so much, Mary. And as always, I look forward to this highly engaging, educational, and entertaining session. So I'm very excited to hear June's edition. So as Mary said, you'll see in your engagement tools the paperclip related content. That's where the resources can be found. And in that, right up at the top, is a link to click engagement tools descriptions. So we found that has been very helpful for people as we segued to this new platform. There is also a link to subscribe to eDiscovery today. Don't miss a thing. Doug is a serial information share 3 times a day, and sometimes even 4. You can also download and view something that I use and so many people use. Doug put together a 2023 Internet Minute infographic with LTMS, and it is really, really nice. So check that out. And then Tom O'Connor dropped a new book, eDiscovery for the Rest of Us. And you can see the link where to learn more and buy that. We highly recommend it. And then you can learn more about Judge Peck and how to engage with him with the link provided. And be sure, do not forget to do this, save your seat for July's important eDiscovery case law on August 1st. And then up next on the EDRM's webinar channel tomorrow, June 28th, how to simplify modern mobile data collection and review. And back to you, Mary.
Indeed. Thanks, Kaylee. So our faculty today includes Doug Austin. Doug is the founder and editor of our EDRM trusted partner, eDiscovery Today, and an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to various and numerous commercial and governmental clients. Doug has published his daily blog since 2010 and has earned J.D. Super Awards 3 times. Tom O'Connor, and who wouldn't want to quote EDRM's one of our more prolific bloggers, Mike Berman, about Tom. Tom O'Connor is a national treasure. He has a wealth of litigation-related ESI experience, helped run the prestigious Georgetown eDiscovery Academy, lectures on recent cases and developments in the law, and has published several books and blogs, and as a consultant. And Mike recently reviewed Tom's wonderful new book. And Tom hails from the great city of New Orleans, and for over 3 decades, he's stewarded the Gulf Coast Legal Technology Center and has a wonderful YouTube channel for long-form interviews. And the one and only Honorable Judge Andrew Peck is a Chambers-ranked senior counsel at DLA Piper, where he advises on copyright and trademark matters, and also serves as a resource for the firm and clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as a United States Magistrate Judge in the Southern District of New York after 23 years, writing many of our first eDiscovery opinions, and then later writing on boilerplate objections, 502D orders, technology-assisted review. And EDRM is very, very grateful to all 3 of these gentlemen for serving on our EDRM Global Advisory Council. Now, Doug, I understand you've packed the agenda with some cases.
Indeed, Mary. Thanks and welcome everybody to our June case law webinar on the EDRM network on our new network platform. And yes, indeed, we do have another set of very interesting cases this month designed to chase away the summertime blues, including a case where a favorite judge of ours stated that discovery is like watching paint dry. So that'll be interesting, as well as cases involving categorical assertion of privilege, pros and cons of relevancy redactions, default judgment sanctions for failing to preserve video evidence, meet and confer over the use of technology-assisted review, and production of hyperlinked documents. And as Mary mentioned, just a reminder, we do welcome questions, and we'll try to get to as many as we can. We'll be sending out a link to the copy to the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. That includes any ideas that are even more exciting than watching paint dry. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistance site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 30,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So, with that said, let's get into the cases. Our first case involves one of our favorite judges, Illinois Magistrate Judge Jeffrey Cole. It's been so long since we've covered one of his cases, we might be a little rusty. So this is the perfect case for us to cover. Thank you. Seriously, though, in this case filed against the defendant over claims that their wood finishing products are defective, Judge Cole wasted no time in setting the stage by stating, "There is a well-worn simile to describe something that is rather tedious and boring, like watching paint dry. Discovery is often like that, and worse. Indeed, we have it on the best of authority that protracted discovery is the bane of modern litigation. So imagine what discovery regarding paint drying must be like." That is along the lines of what we have here, and counsel in this case, about a dozen of them, have been arguing over it for about 4 months. To make things a bit more tedious, the disputes they have been incapable of resolving are, to varying degrees, over trivial routine matters. So in this case, Judge Cole ruled on 2 conflicts. The first involved the defendant's request for the plaintiff to answer interrogatory number 11, which asked for each photograph plaintiffs produced in this action without metadata showing the date the photo was taken, specify the date the photo was taken as accurately as possible. The second dispute related to plaintiff's request for the defendant to disclose non-custodial and centralized sources of relevant ESI. Regarding the first dispute, Judge Cole stated, plaintiffs refused to provide dates relating to the photograph on the ground that the defendant exceeded Rule 33A1's limit of no more than 25 written interrogatories, including all discrete subparts. Plaintiffs say that there are 32 discrete subparts in interrogatories numbers 1 through 5 and 8 for a total of 36 interrogatories before interrogatory number 11. Defendant insists there are no discrete subparts and that in interrogatory number 11 is just that, the 11th interrogatory. Noting that judges have discretion in determining the correct counts, Judge Cole stated, as it happens in this case, both plaintiffs and defendants' lawyers have counted wrong. Throwing in interrogatories numbers 6, 7, 9, and 10, that makes interrogatory number 11 the 20th interrogatory. Another court might see it differently, but no matter. 20 is less than 25. So we ordered the plaintiffs to produce that information. Regarding the second dispute, Judge Cole stated the problem is that the defendants' counsel say they have repeatedly met and conferred regarding non-custodial locations of documents and have claimed to have gathered and searched for a staggering number of documents. The product isn't one that caused death or disfigurement or disability. What is involved is a $35 can of paint, or in each case, several $35 cans of paint. The fact that plaintiff's counsel wants to certify a large class of allegedly cheated paint buyers doesn't change what the case is actually about. If plaintiffs want more information on those document locations than defendants' attorneys swear they've already provided, the plaintiffs will have to issue appropriate interrogatories. So, Tom, is discovery really like watching paint dry, or is it just that some parties make it that way?
I don't know why discovery gets such a bad rap here. You know, who doesn't get excited about? Yeah, who doesn't get excited about a patent dispute over the application of the doctrine of equivalence in the context of patent claim elements regarding the formulation of chemical compounds? I mean, doesn't that just stir your blood? And who can forget the famous 2006 Supreme Court case of LabCorp of America versus Metabolite involving a patent dispute over the correlation between levels of homocysteine and vitamins B6 and B12. I mean, what could be better than that? Come on. I don't get it. I don't get it. But here, look, let's face it. When the judge says you're arguing over trivial and routine matters, and it has to teach you how to count to 22, then, you know, it seems to me that you're arguing over things that would not be well served by taking up the court's time. And the judge seems to have lost his patience here, so and rightfully so. So I'm going with door number 2. Sometimes the party just make it that way.
Yeah, and indeed, that seems to be the case. And hopefully none of you think discovery is like watching paint dry. Otherwise, what are you doing here? So Judge Peck, Judge Cole made a big deal about the fact that this wasn't a case involving a product that caused death or disfigurement or disability, but allegedly cheated paint buyers. Did the level of product liability ever matter in your decisions when you were a judge?
No, but the level of, fighting over nonsense certainly did. And I think that, one of the, questions where the judge talked about this, considering the importance of the issues at stake in the action, I mean, that is one of the proportionality factors as such. Judge Cole didn't use it in that sense, but he made clear that this wasn't the first hearing in the case where the parties brought motions over nonsense. And, basically he was telling them, get a life, cut out the nonsense, let's get to the heart of the case. And yes, I had similar interactions with lawyers in some of my hearings.
I'll bet. So, Mary, what recommendations do you have for our audience to try to minimize the disputes over what Judge Cole called trivial routine matters?
Well, the first thing would be to know your judge. And does your judge have patience with these kind of trivial arguments? That'd be one. Certainly look for the judge's name on the cooperation proclamation. That would give you another clue as to, how collaborative you should be about the routine matters, and then also consider having an ESI protocol, something to start with, um, uh, so that you're not necessarily always on your back heel. It would seem that these attorneys got into the minutia, and in one way you could have 22 interrogatories, and in another way you can have a different number of interrogatories. If you're on those kind of an arguments, it's probably a losing argument, or losing for the case anyway.
Yeah, it does seem pretty amazing that they can't even agree on the number of interrogatories. But fortunately, Judge Cole dealt with the issue. And thanks, Ira, for the comment about the new platform. Glad you're loving it. We'll move on to the next case, which involves claims of wrongful termination for essentially whistleblowing, reporting potentially unlawful conduct by the plaintiff's managers, where the plaintiff filed a motion to compel the defendant to respond to discovery requests and provide materials from 2 internal defendant investigation files, one of which, after the defendant agreed to release the other one, related to plaintiff's complaints about improper business conduct, which plaintiff contended that defendant asserted a blanket privilege over them and provided an inadequate privilege log. Defendants maintained the materials in the August 2018 investigation file were not relevant to plaintiff's claims and were otherwise protected by the attorney-client privilege and work product doctrine. Deciding the relevance dispute first, the Pennsylvania District Judge Jagan Ranjan stated Mr. Tucci is entitled to discovery that is relevant, non-privileged, and proportional to the needs of the case. The second amended complaint alleges that Mr. Tucci reported misconduct to Gilead's legal department in August 2018, and that Gilead's legal department launched an investigation into this misconduct. As part of that report, Mr. Tucci provided Gilead's legal department the names of his supervisors who he alleged were involved. Mr. Tucci alleges that he was retaliated thereafter by these supervisors, including through unjustifiably negative performance reviews. Based on this, the court finds that the August 2018 investigation and associated file documents are clearly relevant. Addressing the privilege claims, Judge Ranjan stated, because Gilead invokes both protections over the August 2018 investigation materials, it must show either that the contents are communications made from client to counsel or counsel to client in confidence and for the purpose of obtaining legal advice, or that the contents were prepared in anticipation of litigation and not in the ordinary course of business. It has done neither. Instead, it asserts a blanket privilege over the entire investigation file simply because the materials underlie the investigation. That argument misses the mark because it stretches the privilege too wide. A party may not refuse to disclose facts simply because that information came from a lawyer. The mere fact that counsel reviewed material as part of an investigation conducted for the purpose of providing legal advice does not of itself subject that material to protection. In sum, Gilead cannot invoke a blanket privilege over the investigation file and must produce responsive non-privileged documents from the file or otherwise provide a log that identifies by document which specific documents are being withheld and the basis for withholding them. So Judge Peck, the judge here, also found that the defendant's categorical assertion of privilege over a relatively small universe of documents to be improper. Do you feel the bigger issue was the number of documents for which categorical privilege was determined, or the type of documents for which it was determined?
I think an answer could be yes, because it really was both. Implicitly, what the court is saying there is that with the small number of documents apparently at issue, Gilead could have done a so-called traditional privilege log, listing things document by document, which is ultimately what the judge ordered. Unfortunately, too many of the early cases under 26b-5 started saying, a traditional log or a log that satisfies 26b-5 is a document by document log, which made sense back in the 90s when maybe a log would have 100 entries. Doesn't make sense when a log today, if done document by document, might have tens of thousands, even hundreds of thousands of documents. Nevertheless, the, you know, it's traditional to do it document by document, has lived on greater than it should. Just one note, sort of not answering this question, but for people in our audience, if they're not already aware of it, to look out for, the Advisory Committee on Federal Rules has approved a proposed amendment to Rule 16B and 26F to have the party, to require the parties to talk about how they're going to do their privilege logs and to advise the court about it at the 16B conference. That is an amendment to the same section that says they got to talk about what they're doing about privilege in general, including discussion of Rule 502D. We'll see if this rule, if it passes after the comment period, will have any greater effect than that sentence had with getting people to focus on 502D orders.
All right. Very interesting. And I think you just identified a new blog topic for me. So I appreciate it, Judge Peck. Definitely wasn't aware of that and certainly want to cover that. So I will look to reach out to you after for more info on that. So, Mary, a lot of eDiscovery software platforms provide the ability to automatically tag emails from counsel as privileged or likely privileged. Is that a good thing?
Oh, it's absolutely a delightful thing, as long as they're doing it as potentially privileged, so that there can be some oversight on it. The idea that a machine could go through and tag as potentially privileged the emails coming from the domains of a client's law firm, and then you could have lists of attorneys that have a dual purpose, business and legal, for a later vetting of what the machine had deemed potentially privileged. It's a wonderful thing, not only going in the input so that you set up your review right, but also going out your productions to be able to discern which things are potentially privileged and might be leaving the protected comments.
So
Yeah.
we're all gonna use ChatGPT to do our first draft. Okay, got it.
Yes. The key with any software is the QC, of course, always. But yes, it's certainly, as we have more data to deal with, automation can be a good thing as long as there's approaches to make sure that it's at the right levels. So, Tom, what guidelines do you have for our audience as to when a categorical privilege log is appropriate versus when a document-by-document log is appropriate?
Well, two things that the judge and Mary touched on. I think the first thing is the volume, the number of documents. If you've got a sufficiently high volume of documents that the document-by-document review would bring up some sort of a proportionality argument, then you can argue for categorical. And the other one is that if you're going to do that, you got to make sure, though, that, as the judge said, you've got to still satisfy the rules in terms of providing adequate information for the court to make a determination if there's a legitimate claim to privilege. And generally, that means disclose the people involved in the communications, if there are any applicable dates, document types, and specificity as to the claim to privilege. You got to give the court enough information so that in looking at that categorical log, it can make an informed decision.
Yeah.
And
Go ahead, Judge Peck.
Yeah, go ahead.
just going back to what we were talking about with Mary, and that is using technology. Shout out to the EDRM privilege log project, which essentially advocates for a metadata plus way of preparing logs, where you get most of the information, what type of document, who the senders, recipients are, et cetera, through use of the metadata that can be pulled out by the review software. And then, you talk to the other side about testing that in certain ways, et cetera, sort of a metadata plus process. So I recommend checking it out on the EDRM website.
Thanks, Judge Peck. Thanks, Judge Peck. It's in public comment form at this time, but very soon it'll be final. The team led by Kristen Traylor is working hard on the comments they received, and the final will be out shortly.
Yeah, actually, a great point, Judge Peck, and certainly look for it on the EDRM site. Question from the audience: are more people using categorical privilege logs today, and what is a judge's position regarding these types of logs? And we have a judge who can answer that question.
Categorical works for certain things. I mean, I think almost everybody nowadays has an agreement with opposing counsel that emails or whatever form of communication from outside counsel after the commencement of the lawsuit doesn't need to be logged. It's hard to come up with some of the other categories. In some cases, yes, in others, no. That's why I've become more of an advocate for the metadata plus type of log than a pure categorical log. But that's one judge speaking, or one ex-judge.
Okay. All right. Great. Thanks, Judge Peck. Let's move on to our next case, which involves the defendant's failure to fulfill its supply contract to provide magnesium over a force majeure claim, and it was suggested by Judge Peck. Here, the plaintiff objected to defendant's production of certain documents in redacted form, requesting that defendant be required to reproduce the documents in unredacted form, arguing that redactions for relevance are disfavored when there's a protective order. Defendant contended that the information redacted was irrelevant and sensitive, so it shouldn't be required to reproduce in unredacted form. The court directed the defendant to submit samples of the redacted documents for in-camera review, which consisted of various documents, including some that had information on magnesium production. While New York Magistrate Judge Catherine Parker, whose 2021 Nichols v. Noom ruling will be referenced later in this webinar, noted that courts have disallowed relevancy redactions from otherwise responsive documents, i.e. documents containing some relevant information. She also said, this court believes relevancy redactions can be appropriate in some cases. Rule 26G certifications are representations that the producing party has acted consistent with the rules and not made objections for any improper purpose. There is no reason that this court can discern to find that a party is able to make good faith relevance determinations as to portions of documents than as to whole documents. She also noted that if a party does not want to produce irrelevant and confidential information to an adversary and redactions can avoid this result, a party should not necessarily be denied the opportunity to redact if redacting would not otherwise prejudice the other side or delay the case. And she noted one downside to allowing relevancy redactions: they can lead to motion practice, which they did here, which often creates additional expense and delay. Still, Judge Parker ruled the court will permit U.S. Mack to maintain certain redactions provided it can reproduce the documents within 2 weeks of this order. U.S. Mack shall reproduce the documents to reveal responsive information about magnesium inventory and purchases, and to reveal column row descriptors as well as graph titles. So, Mary, how common is it for parties to look to apply relevancy redactions, especially when there's a protective order in place?
Doug, I had to really search my memory banks for the times when relevancy redactions happened when I was hands-on, and it was in the early days of eDiscovery where organizations were trying to protect trade secrets, and it just became so cumbersome. Privilege redaction is difficult enough. The trade secret redaction is even more fraud, I think. So then I did a little bit of research, and Mike Berman of the lovely Tom O'Connor introduction, says that relevancy redactions are not in common practice, and I say that he gets to win.
All right. Well, that's kind of what I thought, but I was interested in your perspective, and good to get his as well. So, Tom, would you do anything different to argue the plaintiff's side and try to convince the judge to compel the defendant to reproduce all the affected documents without relevancy redactions?
Well, I think it's uphill sledding here. The judge, stated it pretty clearly. she was going to allow redactions unless redacting would otherwise prejudice the other side or delay the case. So, if I could somehow show some sort of prejudice to my side or some, unconscionable delay, certainly the second part seems likely. She set a time frame, a pretty short court time frame in this. I just think it's going to be pretty hard to do.
Yeah. Certainly in this case, it seemed like while she provided the arguments all around, she certainly provided several arguments that allowed it. So Judge Peck, given a need for in-camera review and motions practice related to relevancy redactions, which, as Judge Parker noted, adds delay, don't they divert from the just, speedy, and inexpensive resolution of a case?
Yes and no. And she did recommend that the parties should have been discussing this in advance, which would mean, one meet and confer, not any motion practice. And what Mary was saying about what Mike Berman reported is absolutely right. At least in the Second Circuit, the case law, mostly from the district courts, is pretty close to unanimous that relevancy redactions should not occur. So Judge Parker went against the grain here, but I think there is good support for what she did. I mean, if the document were completely irrelevant, we trust, or completely relevant, we trust the lawyers to make that decision. The problem is a lot of the relevancy redactions made documents look like Swiss cheese. There would be a sentence there that was allowed to be revealed and the rest of the page blank, or, a sentence produced and the next sentence was redacted, and then 2 sentences later, and et cetera, et cetera. That, I think, does not make sense. But going back to the paper discovery days that I grew up on, it was not at all unusual in, tender offer litigation or other things where there was a board meeting. And, 5 topics were discussed at the board meeting, one of which had to do with the lawsuit, and the other 4 were totally unrelated business matters. And you would leave in the headings so people would know that you were redacting something that was not relevant, but redact the content and only produce the content of the section that was relevant. That sort of redaction, and that's sort of what was going on here, but with columns and rows and spreadsheets, makes sense. There was a great article by Andrea D'Ambra and David Kessler, 2 unknown lawyers in the eDiscovery field, a while back. Yes, that was sarcasm, in the New York Law Journal, about why relevance redactions should be allowed. So between that and Judge Parker's decision, I'd say people should go for it, but go for it intelligently so we don't wind up with a circuit court decision that throws the baby out with the bathwater because somebody went too far.
Yeah, indeed. Intelligently and cooperatively, probably, right, Judge?
Exactly.
Yeah. So before we get to our next case, a question from the audience. What's the best way to handle redaction of non-party individuals that are listed in the middle of documents to be produced as part of discovery production? I guess that's technically a relevancy redaction. Any comments on that?
I mean, to me, it sounds like it's sort of a privacy issue. If it's a document that we brought over from Europe for U.S. discovery, and the names of individuals are considered certainly to be private information to be protected under the GDPR, that would make perfect sense. But it depends on context, because if one is saying, I had a conversation with Joe Blow yesterday, and he said that, our competitor was doing such and such, and why don't we do that as well? Or whatever it may be information that is very relevant to the litigation.
Yep.
So we all know the answer. It depends.
Indeed. Well put. All right, so we'll move on to our next case, which sadly involved the suicide of an inmate at the Kitsap County Jail and the alcohol and opioid withdrawal assessments of the inmate leading up to the suicide. And this case was also suggested by Judge Peck. Here, plaintiffs emailed and faxed litigation preservation letters to the Kitsap County's Sheriff's Office and Prosecutor's Office, requesting Kitsap County preserve all video audio footage of Mr. Rapp while in custody, both while alive and deceased. According to Lieutenant Keith Hall, who was tasked with managing the Kitsap County Jail surveillance system, the Kitsap County Jail maintained a 60-day retention policy for video recordings in the jail, so the videos were still available when the request was sent. Were they all preserved? No. Lieutenant Hall determined, apparently unilaterally, quote unquote, that the relevant event for purpose of information preservation was Mr. Rapp's suicide. However, Lieutenant Hall did not personally watch all footage captured during Mr. Rapp's incarceration. 11 hours of video were ultimately deleted pursuant to Kitsap County's data retention policies. Kitsap County didn't mention in its production response that the video had been deleted. Only when plaintiffs reached out seeking the recordings did Kitsap County confirm that they did not have that video footage. Regarding the video spoliation, Washington District Judge David Estudillo stated, the court notes with astonishment that Lieutenant Hall was apparently solely responsible for determining what videos were or were not responsive to plaintiff's litigation preservation letter. Kitsap County has provided no other evidence or assertions to the court about what role counsel played in the document preservation process in the aftermath of Mr. Rapp's suicide. He also said the court cannot find Kitsap County acted reasonably when it took no steps to implement what have long been considered standard ESI preservation practices. Finding intent to deprive, Judge Estudillo said, the totality of the circumstances suggest it is appropriate to infer Lieutenant Hall and by extension Kitsap County intended to deprive plaintiffs of the 11 hours of videotape from January 1, 2020. And stating that Kitsap County deletion of this video in defiance of plaintiff's preservation request and in the absence of guidance from legal counsel interferes with the rightful decision of the case, and that an adverse inference instruction for one defendant, which needed to be completely disregarded for the other defendants, would confuse the jury and create a risk that the jury would impermissibly consider the adverse inference when determining the liability of the other defendants. Judge Estudillo issued a default judgment against Kitsap County, awarding attorneys' fees and costs to the plaintiffs regarding the spoliation of evidence, with damages to be determined at trial. So, Tom, who's at fault here? Lieutenant Hall, counsel for Kitsap County, or both?
Both. I mean, normally you'd think, well, there's an officer involved, and maybe it's a line officer who got kind of thrown under the bus to take responsibility for something that he didn't quite understand. But the judge, as you just stated, found that both Lieutenant Hall and the county council were clearly intending to deprive. I think, if you read the decision, Lieutenant Hall was making decisions, had been doing it for some time, understood the litigation hold process. He wasn't just some random officer who'd been thrown into the video room and told to do something. So I think, he was certainly in a position to make a judgment as to whether this was an intentional intent to deprive, and the judge felt that he had. But likewise, the lack of supervision or any attempt to oversee what not just the lieutenant, but anybody at the Kitsap County Sheriff's Office was doing by the prosecutor in this case is, as the judge said, simply astonishing. It just kind of makes it seem as though they could do whatever they wanted, and the prosecutor's office, the county attorney's office, was paying no attention and and deliberately looking in the other direction. So the judge found them deliberately intending to deprive also. So I'm going with both.
Yeah, that's certainly seems the case. Great point about the fact that this Lieutenant Hall was experienced here. This was not his first rodeo, so to speak, with regards to preservation and what have you. So certainly a notable factor there. So Judge Peck, do you agree with Judge Estudillo's reasoning not to consider an adverse inference sanction because of potential confusion with the jury that might lead to them applying it to the other defendants?
No. And by the way, one other thing, having been involved with the judge on lawsuits against various of the jails and prisons in the New York area, reminds me of Judge Ian Johnston's decision that we covered a while back, where he said, well, it could have been intent to deprive, or maybe the party could argue that it was just total incompetence and, let the jury decide that. Knowing a lot of these jails and their responsiveness to their own lawyers, I might have let that question go to the jury. Another issue for the audience is most of the time the entity is exempt from the lawsuit in a lot of the cases we see under Section 1983. So you've got the entity responsible for all the video and the line officer, not a lieutenant, but just a simple correction officer, being the defendant, and how do you deal with that? But that was a long preamble. One obvious solution here that the judge could have contemplated and maybe even made the county pay for it is to have two juries sitting there hearing all the evidence. And when it came time for the instructions, one jury, the one dealing with Kitsap County, would get the spoliation adverse inference instruction, and then they would be sent out, and the other jury that's dealing with the other defendants would get the regular instructions and not that. These are usually 8 or 9 person juries, not 12 plus. That would have been an easy solution and much more appropriate, perhaps, than a default judgment against a government entity.
Had not considered that as an option. Very interesting. Thanks, Judge Peck. So, Mary, what recommendations do you have for our audience to keep ESI custodians from "quote unquote" unilateral responsiveness determinations?
Well, that's the question here, and that is oversight. Definitely oversee their collection. You may want to interview them while you're sharing their desktop or sitting desk side back in the olden days, but certainly to allow your custodians to do what has been affectionately termed self-preservation it's not a good idea, especially if somebody's involved in the matter or has a particular way in which they think, and having a preservation letter that very clearly spelled out what was being sought, and then allowing their internal client to go in and, without any oversight whatsoever, choose what would be saved and what wouldn't be saved, and then not disclosing it at the appropriate time. Those are all recipes for disaster. So don't do any of that.
Good advice. Don't see this bad stuff here. Don't do that. That's why we do these webinars. We show people what not to do in a lot of these cases, and that's a perfect example. I wonder in this case, back to Tom's point, if because the fact he was experienced, that they trusted him a little too much, and maybe that bit them in this case. So. You could certainly see that happening, I wonder. Regardless, we'll move on to our next case. which relates to claims involving the recording habits of Amazon's Alexa devices. And apologies to any of you whose Alexa just went off when I said the word. Where the court granted plaintiffs' motion to compel searches in October 2022 of the ESI of 36 Amazon employees using 38 search strings as proposed by the plaintiffs. Using the approved search terms, defendants identified approximately 2 million potentially responsive documents. Within 2 weeks of the court's order, defendants notified plaintiffs that Amazon intended to use TAR tools to prepare its production, promising that they would discuss these tools with plaintiffs before beginning review. But the plaintiffs objected, asserting that applying TAR at this stage, after the parties have agreed to search terms as a basis for culling documents and after the court issued an order on search terms and custodians, is improper and impermissible, arguing that it was too late to alter the protocol to produce ESI in this case. While the defendants disagreed because of the large number of retrieved documents, plaintiffs again objected to any effort to use TAR to further review and filter the documents retrieved by the court-ordered search terms. Considering the dispute, Washington District Judge Robert Lasnik noted the plaintiff's refusal to discuss TAR, stating, "While defendants' discovery conduct has not been beyond criticism, the nub of this particular discovery dispute is that when Amazon raised the issue of using TAR, plaintiffs refused to discuss it. This was not a valid option given the circumstances. Courts generally agree that the producing party is best situated to evaluate the various options for reviewing and producing its own ESI and places the burden on that party to make an initial detailed proposal about the technology and methodologies it intends to use. The requesting party then has an opportunity to consult with its own ESI discovery experts so that it can intelligently respond and the parties can move forward toward an agreed protocol for the use of TAR. By refusing to discuss the use of TAR at all, plaintiffs improperly short-circuited this process." Judge Lasnik also ruled on the plaintiff's concern about the fact that the TAR process identified only 2,564 responsive documents out of an initial universe of over 2 million, stating, "Plaintiff's concern regarding the incredibly low production rate, which was less than 0.13% of the documents returned using the search terms, may be valid, but it does not appear to be related to Amazon's use of TAR. Humans reviewed over 89% of the documents identified using the agreed upon search terms and found that only 2,564 of them were actually relevant, responsive, and non-privileged. The 224,924 unreviewed documents are, according to the TAR methodology, the least likely to be responsive, and in fact, a human review of 1,527 of them revealed no responsive materials." So Judge Lasnik denied the plaintiff's motion to prohibit the defendant from using TAR. So Judge Peck, last year we covered the In re Allergen case where the special masters didn't approve the late decision to use TAR, and it was cited by the plaintiffs as part of their argument here. Why do you think that the court approved TAR here when it wasn't approved in that case?
I mean, I think the biggest difference is the court's attitude towards the use of TAR. I mean, the court here said, in this district, it is presumed that the use of technology-assisted review is a reasonable option, et cetera, et cetera. That sort of put the thumb on the scale that TAR is good. I think this is also a question of, and we'll be talking about it in the StubHub case next, of what was in the ESI protocol. In Allergen, their hands were sort of tied by the protocol. Here, the protocol, as I'm reading it in this opinion, is that the parties were supposed to talk about anything that they were going to be doing to review the things that were hit, the search term hits. And I guess the last point is this shows how bad the keyword search term or search term strings were, that there were so many hits with such a low actual responsiveness rate.
Yeah, overbroad doesn't begin to seem enough of a term to describe it here, for sure. So yeah, absolutely. Thanks, Judge Peck. So speaking of that, Mary, what do you make of the fact that only 2,564 responsive documents out of more than 2 million were identified as responsive? In a typical case like this, what could a producing party do to demonstrate to the court that the requesting party searches are overbroad?
Oh boy, it's our old favorite data reduction exercise in documentation. So certainly looking at the facts of the case and what's in scope, your claims and defenses, creating a series of reports that demonstrate that certain search terms or search strings were overbroad. And here they sampled it looks like 1,527 documents out of so many. They may have stratified it and maybe said for certain custodians, for certain time periods, for certain types of data, that we're going to sample those tranches and be able to excise whole pieces of data. So it's all in the reporting. And some of the most effective reports are search terms going down a spreadsheet, since we were talking about spreadsheets in the previous case. So going down a spreadsheet and then search terms going across, and then the number of hits for both of those search terms. And then I believe some of the tools actually have cubes, so you can do it in 3 dimensions. But that's what I recommend.
Sure, absolutely. And obviously, in this case, they did a review of 1,527 of the 224, almost 225,000 unreviewed documents to demonstrate that there weren't really any responsive materials left, or very little likely. So it's certainly a lot easier to review 1,527 to prove the point than review them all, right?
Exactly.
For sure. So, Tom, why do you think so many parties object to the use of TAR after search terms are applied? Do you think it's still based on a lack of trust of the technology and approach, or do you think they're simply trying to drive up costs for the producing party and force a settlement?
I'm really shocked, Doug, that you insinuate that one party in litigation would deliberately do something to make the other side run up their costs. That just I've never seen that. I think there's a couple of things that could have happened here. The first is we don't know how well the parties are getting along in this case. Were they, at each other's throats? Were they cooperative, or were they reluctantly cooperative? And that I say search terms, you say TAR. And nobody's going to agree. And then part of that, of course, is, the assertion that it's too late to change the protocol. We agreed on search terms, and the kind of the attitude that the protocol is written in concrete, right, and cannot be altered. And the response to that is, well, we use the search terms, and we came up with this 2 million potentially responsive documents. Obviously, that's search terms aren't the best way to proceed with this. Now, that brings up another thing, another argument, which is somebody could have said, the objecting party could have said, as Mary alluded to, well, why don't we try a little different culling down strategy here? How about instead of 36 employees, let's try the search strings with, 5 and see what we get, or 10. And then, of course, we don't know what those search strings were. I mean, there's an assumption here that the search strings were well crafted. Without seeing them, I don't know that that's true. And very often I find that it's not true at all.
Right.
I was involved in similar.
They were ordered by the court, so of course they were reasonable.
And probably after 2 months of bickering, you would have signed off on whatever they agreed to, right, Judge? Like, go ahead, just do it. Stop arguing here.
No comment.
Yeah. I was involved in a similar case recently in another county in the state of Washington, and very, very similar search circumstances where when we started digging down into it after a similar result, the search strings were just really not well crafted. So, I think there's a couple of things that could have gone on here, but underlying it, certainly there's always a misunderstanding or a lack of trust of TAR by parties. Why wouldn't you want to use TAR to try to do this quickly and efficiently?
Yeah.
I mean, the only legitimate argument, perhaps, is, look, whatever the search terms missed, whatever that amount of potentially relevant documents, well, obviously TAR isn't going to find them because that's not going into the TAR tool. But neither are human reviewers.
Right.
So the only argument would be, well, if you're going to use TAR, use it to begin with without doing search terms. And if the search term universe here was 2,500 responsive documents, can you imagine if there was 2 million documents hit on by the search terms, can you imagine what would have gone into the TAR tool if they didn't use search terms? So
yes.
People have to get more
36 employees, right?
Yeah.
We don't know what the date frame was there. 36 employees,
Yeah, obviously seems very broad terms. And certainly one thing notable, I think, about this case, because when I asked Judge Peck about the N-ray allergen case, they had a protocol in that case, but the defendants essentially kind of unilaterally proceeded to say, we're going to use TAR without really, any discussion, which is what the protocol called for there. Here, obviously, the defendant was willing to discuss how TAR was performed, and the plaintiffs simply wouldn't do it. So certainly notable in that case. We are getting close to running out of time, so I better move on to the last one so we can get it in, which is a very important one. And it's another case where the judge, in this case, California Magistrate Judge Thomas Hickson, had something to say at the outset of the ruling when he said this. This order is about agreements. Without them, courts would have to rule on everything, and litigation would be even more expensive than it already is. Courts encourage parties to work out things like ESI protocols and other procedures governing discovery. We do this because we assume that the parties have some idea what they want to obtain in discovery. They know much better than the court what is possible or feasible, and they are best able to estimate the costs involved in whatever they agree to do. And when parties reach an agreement, we ordinarily need to hold them to it. Otherwise, if discovery agreements routinely turn out to be worthless and unenforceable, we deprive the parties of any reason to enter into them. In this case, the parties agreed to and the court ordered an ESI protocol, which stated, among other things, if any member of a family group is produced, all members of that group must also be produced or else logged as privileged, and no such member shall be withheld from production as a duplicate. Hyperlinked files must be produced as separate attached documents. Comparing to another notable case with hyperlinked documents from Judge Parker that I referenced earlier, Judge Hickson stated, this is not a case like Nichols v. Noon, where the defendant refused to treat linked documents as attachments, and the court had to decide whether to order that or not. Here, StubHub did agree to do that, and both sides agreed that with a handful of exceptions, it has not lived up to that part of the ESI protocol. Neither has StubHub moved to modify that protocol. So he stated, let's get back to basics. Litigants should figure out what they're able to do before they enter into an agreement to do something. Litigants should live up to their agreements, especially when they are embodied in court orders, as the ESI protocol is here. And if for some reason a party learns that a so-ordered discovery agreement has become impossible to comply with, the party should promptly move for relief with a good showing that despite its best efforts, compliance is impossible. In this case, StubHub has decided to do none of the above. As a result, he granted the plaintiff's motion to compel and ordered the defendant to produce the linked documents as agreed to in the ESI protocol, or produce for deposition within 14 days after the deadline to complete document production, and a Rule 30b-6 witness with full knowledge of everything StubHub and its vendors did in attempting to produce linked documents as attachments as required by the ESI protocol. So, Mary, how could StubHub have better positioned themselves before the ESI protocol was agreed to and entered into court order?
Well, that's a clarion call for litigation readiness and for having having a process to produce that you can use early in a case to generate a sample file, and then you would know. So first, you don't go to the meet and confer and agree on something that you have no idea that you can do or not do. You don't do that. But if you got it over your skis and you did a sample file, at least you'd be on notice in time to do what Judge Hickson says, which is basically come clean, tell the court and explain what you tried to do and why it's impossible. And you need time to do that. You can't wait to the last minute.
Yeah, without a doubt. Don't find out you can't do something after you've already agreed to do it, right? So, so Tom, given the difficulty to treat linked files as attachments, not to mention the potential that a linked file could be changed or even deleted after being linked in a message, is it time to scrap the expectation of parent-child relationships for messages?
Okay, so first, just a definition. By messages here, you do mean emails and not...
Yes, I include emails in that because any type of message could have a linked file in it.
Yeah. So, in mindful of time, my answer to that question is no. That they agreed to it. I'm not granting the premise that treating linked files as attachments is problematic. And certainly they said that they could do it. And if all of a sudden they realized that they couldn't do it or there was an issue in doing it, they should have raised that. And as the court said, they didn't. What they did was nothing. If they couldn't produce the linked documents, if there's some reason why, then, what's the explanation? The court itself said they had, quote, settled on a clear story for why producing the linked documents can't be done. So I don't know that it's a given that it was overly difficult or, we don't know. It's impossible to say, so I'm not going to guess. I don't think it's all that difficult.
Mm-hmm. Okay. So I'm going to ask a question to Judge Peck, but since got a comment here that kind of ties in, from Gareth, I'll go ahead and note that. So it seems to me that this is more of an ESI protocol case than a duty to produce hyperlinks documents case. It was solely determined by what the parties agreed to do in the ESI protocol. Lesson, be careful how you define a family in the ESI protocol. So Judge Peck, both Nichols v. Noom and this case came down to how the handling of linked files was addressed or not addressed in the ESI protocol. So hypothetically, in the absence of an ESI protocol or other agreement beforehand, what would you need from the parties to rule on how linked files should be handled?
Very briefly, I agree with Gareth. The biggest lesson here is be careful what you agree to in an ESI protocol. And we are seeing that. We saw that in one of the other cases we discussed today on this webinar. People are agreeing to things and then not living up to it. But in the absence of that, what email system is StubHub using? Are they in a Microsoft 365 world? Are they in a Google world? What is their ability to get to the linked documents? What was the what was the review protocol that was being used by StubHub to review? If you, as I understand it, if one is just exporting custodial email files to a review company or outside law firm, that breaks the link. And then it becomes putting Humpty Dumpty back together again problem. If one has the right level of Microsoft or Google and does that review internally, there may be questions, there probably are questions about, is the link the same one or did it get updated at a later point, et cetera, et cetera. But at least some version of the link stays with the parent email. So it's what environment is the company in and what was its review strategy of how they were going to deal with it.
Yeah.
In this
Indeed.
hypothetical.
Yeah, and absolutely. And certainly the fact that StubHub did nothing was certainly not the ticket with Judge Hickson here. So so I'm going to move to our contact page, and one additional question from the audience we didn't get to, so I'll touch on it briefly here. Does the amount of video requested to be preserved make a difference? What if the preservation letter was all video amounting to 11 weeks worth rather than 11 hours? Does proportionality of the burden of preservation matter? Judge or anybody, your thoughts?
I say no.
I'd say yes, but it depends. The problem is if you as the producing party makes a unilateral decision that it's too much, then you face the risk that the court finds it's not too much. But obviously, if the inmate had been in prison for 11 weeks or 11 months or 11 years, proportionality applies. The question is, when is it going to be determined?
Yeah, absolutely. So we have a date for our next for our July case law webinar on Tuesday, July 32nd. Actually, it's August 1st.
I see what you did there.
Indeed, same bat time, same bat channel. We had tried to work it into July, missed it by one day. So until then, I'll say thanks to Mary, Tom, and Judge Peck, as always, for their terrific insights. And I'll turn it back over to you, Mary, to close us out.
Excellent. And EDRM thanks you, Doug, and Tom O'Connor, and the Honorable Judge Peck for this wonderful presentation. And our thanks to the EDRM community for your kind attention. We'll see you next time on the EDRM Global Webinar channel. Thank you.
Bye, everybody.
Thanks, everyone.
Bye, all.